Like that?
Yep.
All right.
You go ahead and watch.
That is never going to happen in real life. Hi, I'm Michelle Marinacci. I'm an attorney and partner at Khourey Turak, and this is GKT Takes On Ginny Georgia, Season 3, Georgia's Murder Trial. One of the first things an attorney needs to do when meeting with a client is explain to them the legal process and what to expect.
Yeah, there is a process.
So here, Georgia's attorney is doing exactly what he should.
So we get Judge Matthews, you know him?
So we're explaining the judge. The judge is an important consideration when framing the issues in your arguments in a case. Understand who your judge is, what their background is.
Okay, he's got a grandson at Wellspring High. That could work for us.
So here the attorney is doing exactly what he needs to do, telling Georgia what to expect. Georgia walks into her arraignment in a wedding dress. That is never going to happen in real life. The attorney usually controls or tries to control what the client wears.
Wedding dress is a nice touch.
Trying to portray herself as an innocent young bride at a murder trial or a murder arraignment, not gonna happen.
Judge. Hi. How's your wife?
All right, so the judge comes onto the bench and Georgia starts talking to him directly and asking about his family. Again, not gonna happen in real life. Her attorney reacted much more calmly than I would have if Georgia was my client. I would have been pulling her down and stopping her a lot sooner than he did.
All right, this bickering needs to stop.
So in this scene, the judge stops the attorney's bickering. That is something that happens every day in court. Not unusual. What is unusual is what happens next. Georgia again tries to talk directly to the judge.
Your Honor, how is Patty?
If this was real life, she would have probably been held in contempt at this point. The first part of the trial has now started, jury selection.
We need to talk about jury selection.
How do we do that?
One of the most critical things you can do in a criminal or civil case is select who the jury is, who's going to be deciding the issues. The attorneys get a chance to question the jurors, and you decide who is or is not going to be on your jury. In this case, Georgia is active in this selection, and she's watching the people, their body language, and who they are, and giving her attorney advice.
I know Wellsbury.
Her advice is a little different than what her attorney may have thought. We'll see later if it works.
How do you know the defendant?
I'm a private investigator.
Okay. So here we have a private investigator who had been investigating Georgia for a number of years and a number of issues. He's called to stand by the prosecution, and for whatever reason, they don't know what his testimony is going to be ahead of time, or maybe they do.
I believe that we are dealing with a serial killer.
Objection! Motion to strike!
That is not happening in a court of law. If you are going to try and bring in past acts or other evidence, there's something called a Rule 404B motion that the court has to hear the testimony ahead of time. Then they decide whether or not the testimony is more probative than prejudicial. You're never going to have a witness in a murder trial being allowed to call someone a serial killer. Georgia's attorney does what any good attorney would do: immediately object and move to strike. The problem is the bell's already been rung. The jury has heard that accusation. In this case, the judge, highly unusual, allowed it to proceed before ruling on the admissibility. Most cases, and I'm surprised this attorney didn't, move for mistrial and stop the trial at this time.
I'm curious. I'm going to allow it for now.
I have to strongly object.
I will rule on admissibility after hearing the witness testimony.
All right, so the judge is allowing our private investigator to keep going back and tell the jury why he thinks George is a serial killer. Again, will never happen. Our attorney immediately objects.
Objection! Opinion, Your Honor. Speculation. Lack of foundation. Relevance. Insane. Do you need more?
He throws in every objection he can possibly think of, including, "This is just insane." An attorney must make an objection and give the grounds at trial if you're going to preserve it for appeal. And sometimes this is just insane results into this is just clear error. There was no actual rule. Also, we have the prosecutor asserting his own opinion as to whether or not Georgia is a serial killer.
Rein it in, counsel. You're dancing dangerously close here.
Close. You went over that ledge a while ago.
Prosecutor, you're not allowed to do. So as we can all tell, Georgia had a disastrous first day in court. She was called a serial killer. When they get home, her attorney does what any good attorney would do. Tell them, don't speak to the press.
Well, I need to figure out how to counterattack this. Don't speak to the press. Don't speak to anyone.
Your initial reaction is always going to be, when you have a bad day at court, I need to get my story out. But the story needs to come out through the attorney's questioning and not speaking directly to the press or witnesses or anyone else.
Do you have any hard evidence at all that Georgia Miller killed Kenny Drexel? Does the state of Texas even view Kenny Drexel's death as foul play?
No.
No!
Okay. Well, the cross-examination worked. The witness got rattled. His credibility was undermined. He looked to the prosecutor for help.
Oh, he can't help you.
There's nothing the prosecutor could do. The defense attorney rightly laughed when he looked to the prosecutor, who then asserted a just vague objection that the damage had been done. The jury does not believe the private investigator at this time. The judge, after listening to everything, excluded the private investigator's testimony. All of that should have happened in real life pre-trial because you can't unring a bell. In the real world, a motion for mistrial would have been made once the judge ruled the testimony inadmissible. In all likelihood, it would have been granted and a verdict would have been reversed on appeal.
Georgia, Paul asked me to stop representing you. I'm sorry.
Can he do that?
Yeah, you can stop paying me.
So here's a problem that happens way too often. Someone else is paying for your representation. It might be an insurance company, it might be someone else. Georgia's soon-to-be ex-husband stopped paying for her representation, and her attorney decided he was going to withdraw. That's not gonna happen. Once you're in the middle of a trial, you're not unilaterally stopping your representation of a client. An attorney has ethical duties to the client to continue whether or not they are being paid by a third party. For that lawyer to have abandoned his client in the middle of a trial, the judge would have had to grant a motion, and I don't see any judge doing that absent really extraordinary circumstances. Not getting paid is not one of those circumstances. So Georgia, by some miracle, found an attorney willing to jump in mid-trial and represent her. And that attorney did what her first attorney should have done from the beginning, is change the narrative.
That's our story. We change the narrative, we spin it for our benefit.
One of the most important things in prosecuting or defending a case is creating your narrative. What is the story you want to tell? It's something we start thinking about from the beginning, putting your case in the best light for you.
The defense calls Austin Miller to the stand.
A child is not going to be testifying in a murder trial absent extraordinary circumstances. If this was the real world, the judge would have been talking to the witness outside of the presence of the jury, determining whether or not he had the ability or could testify truthfully. Ultimately, it would be the judge's decision. Most of the time, I don't think it's going to happen absent extraordinary circumstances.
In the case of Georgia Randolph against the state of Massachusetts, find the defendant not guilty.
It looks like changing the narrative worked. Georgia was found not guilty. In the real world, this case likely would never have made it to a jury. There would have been a mistrial. Ginny and Georgia, like most fictional courtroom depictions, take great exaggeration in what can and cannot happen in a court of law. Any show that you watch, any movie that you watch where there's courtroom scenes, if you're sitting next to a lawyer, they're going to be telling you, That's not gonna happen in the real world. Ginny and Georgia got some of it right, they got some of it wrong, but in the end, it was great entertainment. Okay, this was GKT Takes On Ginny and Georgia. Case closed. We'll see you next time.